So the Supreme Court recently heard oral arguments in the case Caniglia v. Strom, which deals with whether or not law enforcement officers can enter your home without a warrant or your consent and seize your firearms when they are engaged in so-called community caretaking. So let's talk about this. But real quick before we jump into this video, if you think that law enforcement officers cannot enter your home without consent or a warrant and seize your firearms, go ahead and hit that like button and subscribe. I also want to give a shout out to one of the main sponsors of the channel, USCCA. If you concealed carry, I highly recommend you look into getting some sort of liability protection like you get through USCCA. Along with your membership, you also get training and education. USCCA is the company I recommend, and if you're interested, I'll put a link to them down in the detail section. So like I said in the intro, the Supreme Court recently heard oral arguments in the case Caniglia v. Strom. This case involves a question of whether the community caretaking exception to the Fourth Amendment's warrant requirement extends to your home. So some quick background on this case and how it ended up in the Supreme Court and how this whole question situation arose. Well, this came out of an argument between a husband and a wife. Mr. Caniglia was in an argument with his wife of 27 years. During this argument, Mr. Caniglia went and retrieved an unloaded gun and asked his wife, "Why don't you just shoot me and get me out of my misery?" As a result of the fight, his wife decided to go and stay at a hotel, and the next morning after staying at the hotel, she called her husband, but her husband, Mr. Caniglia, did not answer the phone. And when he didn't answer, she became concerned for his safety, so she called the police, told them about the argument they had the night before, and the police went to the home and spoke with Mr. Caniglia. Ultimately, Mr. Caniglia was taken for a psychiatric evaluation, but was discharged on the spot after the evaluation. However, in the meantime, police officers entered the Caniglia home without a warrant or without the consent of Mr. Caniglia and seized Mr. Caniglia's firearms, claiming that it was part of their community caretaking responsibilities. Now, this case, as you can tell, doesn't directly deal with Second Amendment rights, but deals more with Fourth Amendment rights and your Fourth Amendment rights from unreasonable search and seizures. However, this unreasonable search and seizure ultimately led to the seizure of Mr. Caniglia's firearms. And this is of great concern to everyone across the nation because the law enforcement officers here are saying that they do not need your consent or they do not need a warrant to enter your home and ultimately seize your firearms if they are engaged in community caretaking. Now, this whole community caretaking exception to the Fourth Amendment arises out of a 1973 Supreme Court decision in Katie v. Dombrowski. In this case, the Supreme Court found that law enforcement officers had not violated the Fourth Amendment when searching without a warrant a trunk of a car that had been towed after an accident. The Supreme Court there found that the officers searching that impounded car's trunk was part of their community caretaking functions. Now, as you can see, that case is much more different than what we're dealing with here in Caniglia when you're talking about a search of an impounded car in the trunk of an impounded car all the way to the consentless and warrantless search of a home. Well, in this case, when it got to the First Circuit Court of Appeals held that the community caretaking exception to the warrant requirement could also apply to home searches. And so that is how this got up to the Supreme Court. Now, like I said in the intro, this case is before the Supreme Court and oral arguments were heard on March 24th of this year. Now, I've watched the oral arguments. They take quite a while. I'll put a link to them down in the detail section if you guys are interested in listening to Supreme Court oral arguments. I think a lot of you probably have never been introduced to anything like that. You've never listened. It's interesting. Just understand a lot of what happens is there are some general statements by each party. They kind of run through their general spiel, and then they are questioned on hypotheticals by the various justices. Now, Mr. Caniglia's counsel was questioned heavily during the arguments on hypotheticals about when law enforcement officers can enter a home without consent or without a warrant. Some of the earliest hypotheticals you see pop up from Justice Roberts was an elderly lady. She's supposed to show up to a dinner. She doesn't show up. This elderly lady is never late. You try to contact her, but she won't answer. 24 hours have gone on. No one's heard from her. It's unusual. Everybody always hears from her, sees her. Maybe even 48 hours go on. When then can the law enforcement officers actually go into her home without consent or without a warrant? They even threw in the hypothetical of what if the door is open in the backyard or the front door. As you can see, there's a lot of hypotheticals that get introduced, and Justice Kavanaugh even addressed plaintiff's counsel, and he said a lot of the hypotheticals you're getting addressed with fall into two main buckets. The first bucket being when dealing with elderly individuals, and the second bucket being when you're dealing with potential suicides. Now, one of the concerning things that I actually saw come out of some of the plaintiff's counsel's responses is he talked about administrative mechanisms with third-party reviews like red flag laws, when people could enter home or law enforcement officers could enter home without warrants or without consent. That was something that was of great concern to me that I heard pop up. And this is, I guess, was presented as an alternative to just police officers being able to enter without consent or warrants. One of the proposals was maybe you go through a third-party administrator or judge or someone like that to get some sort of basis to enter a home. Now, on the other side, the defense counsel was questioned heavily on how they got from the community caretaking exception in Katy, which dealt with impounded accident vehicles and searches of those vehicles, all the way to consentless and warrantless searches of homes. Because like in Katy, there was a great distinguishment made between cars, vehicles, and the home. Homes historically, in American history, even well before that, have been treated much differently than other locations or your vehicles or other properties. When it came to your homes, you have this basis of a right to be secure in your home, and again, under the Fourth Amendment, being secure from unreasonable searches and seizures. And so a lot of the justices were very concerned about how defense counsel got all the way from this exception applied to impounded vehicles all the way to applying that exception to consentless and warrantless searches of homes. And one of the main concerns that came out of this, and a lot of the justices asked, is if you apply the community caretaking exception, what are the limits to that? Almost anything can fall under the community caretaking guidelines of law enforcement officers as long as they are operating for public health and safety. Almost anything could fall under that purview, and almost under any circumstances could they enter someone's home without consent or without a warrant. Which is very concerning for me and you, especially when you're kind of talking about situations like this where someone may wrongly call law enforcement officers on you, and then the law enforcement officers are saying, hey, I'm going to enter your home, seize your firearms because I'm doing this for your health and your safety, and this is being all done under our community caretaking exception. So that's why we should all be really concerned about the outcome of this case, because it affects primarily our Fourth Amendment rights and potentially applying a very broad exception to our Fourth Amendment rights, but also could have greater impacts for things like our Second Amendment rights, where law enforcement officers could enter our homes without our consent or without obtaining a warrant with probable cause, and therefore going into our homes and seizing firearms. Now, the Supreme Court has until about June to make a decision on this case, so fairly soon we should be getting some sort of determination from the Supreme Court, and I will definitely let you guys know. Again, I would highly recommend, if you have time, listen to the oral arguments. You will actually get to probably hear oral arguments for the first time, because I know a lot of people haven't really dealt with these types of things. They've never really listened to Supreme Court oral arguments. So if you guys have any questions, go ahead and comment down below, and I'll try to answer to the best of my ability. Also, if you guys like this video and like support the channel, one of the best ways to do that is to like, comment, subscribe, and make sure you hit that notification bell, because that helps the channel analytics, helps us spread the word about the Second Amendment, also spread the word about things like this that are going on in the US to affect our Second Amendment rights. So as always, thank you all for watching. Don't forget to like and subscribe, and never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.